So if you can, I just want to make sure that everybody can see my screen. It should have up the importance of estate planning.
Yes, I see it.
Perfect. All right, thank you, Michael. As Michael says, my name is Thua Barlay. I'm a partner with Lueder, Larkin, and Hunter. I manage the estate planning practice, as well as I manage the closing practice for the Conyers, Covington, and Stockbridge offices. So I do both real estate and estate planning. Today's conversation is going to be about estate planning. It's talking to realtors in particular, but it's also talking to those of us who are not realtors. And it's talking about the importance of estate planning. So we'll talk about some of those things. I want to apologize in advance. I do have some construction going on behind me. So hopefully I'll speak loud enough that you can hear me. Throughout this presentation, if you have some questions, feel free to ask any of those questions. Depending on how far we get, because we only have an hour to share such an important topic that typically lasts a little bit longer than an hour, I'm going to try and address as many questions as I can. And for those questions that I can, I'll have my contact information at the end to provide to you in case you need to call me offline and ask those questions. So without any further ado, I'm going to continue on with the presentation. So today we're going to talk about a few things dealing with estate planning. So we'll talk about estate planning basics. We'll talk about control, your clients maintaining their control through a period of disability, because we know that a majority of them are going to go through a period of disability before they pass away. So how do they continue to maintain that control over the assets that they've acquired, primarily in your case, real estate properties? We'll talk about ownership. There are various ways that your clients and individuals can own real property. And so we'll talk about how the title is involved in owning that type of property. And then, of course, throughout the life of the property, throughout the life of any asset that they acquire, they will have to transfer those assets. And so you, as a financial a real estate professional that advises them, will help them in some of those. And then we'll kind of look at some real life issue spotting, things that you as a real estate agent should be aware of to be able to properly guide your clients. So throughout this discussion on estate planning, those are some of the topics that we're going to look at. As I do with all discussions, we always want to define what we're talking about. So in this case, we're talking about estate planning. That definition is in front of you. It's from your individual standpoint. I want to control my property while I'm alive and well, give what I have to whom I want, take care of myself and my loved ones if I should become disabled, give what I have to whom I want the way I want. And then lastly, save every last tax dollar, professional fee, or court cost legally possible. So the most important aspect of that is control, maintaining the control that you have. Obviously, when you are alive and competent, control is not an issue. You're able to handle it the same way as you would with any other asset. Really what happens, what comes into play is the disability aspect of it. So again, when you become disabled, and we know that the majority of us will go through that period, so it's not like we're just not going to wake up the next day. We're going to go through a period of disability. How do we continue to maintain that control during that period of disability? And so estate planning, when I talk to people about estate planning, it's not about wills, it's not about trust, it's not about the death, but it's about that disability. And I think that's probably to some certain degree more important than the death or planning for the death. And of course, the subjectivity of things. I tell clients all the time, you can be subjective. These are assets that you've worked hard for to acquire. And so you have this ability now to determine who you want those assets to go to and how you want them to go to. And then the last aspect there is really just saving. The earlier on you plan, the more you can envision those costs in the long term. So that's really, I think, the core definition of estate planning. So in order for me to define estate planning and talk about some of the scenarios that the issue spotting scenarios that will come about, we're going to come up with a fictional clients for you. So your clients in this case is Fred. I think most of you are familiar with Fred Flintstone. He is married to Wilma, and they both have a child, Pebbles. So we're going to fast forward, and Fred and Wilma, they currently own their home in Bedrock, California, but they're planning to move to Atlanta. So we fast forward 25 years later, they still maintain their home in California, but they're now in Atlanta, and you're helping them with properties here in Atlanta. It's also 25 years later, so Pebbles is now grown and she's married Bam Bam, and they are starting a new family. And so we'll talk about that. And oh, by the way, Fred also has a partner in his business. So Barney also moved from California. He liked Fred and Wilma so much, he also moved from California out to Atlanta. And so Fred has a partner called Barney. So we'll be talking about these individuals when we talk primarily with our issue spotting, but also when I talk about estate planning basics and some of the things that we need to address. Now, in some of the basics, there are four general types of estate plan. There's the most prolific of all, which is the first, no planning at all. We know that 60 to 70% of the general population uses this first type of plan, where they don't plan at all. And so I'll explain to you what occurs in a situation where people do not plan. And as you, as a real estate agent, would be focused on that area because it makes your job a little bit harder. We'll talk about title-based plan. And title-based plan is when individuals, either single, married, or with their partners, own property. And so title-based plan is how they own that real property and how they can transfer that property. Then the last two are will-based and living trust. There are will-based plans and living trust. How I always explain the difference between a will and trust is by using an analogy. It's almost like an analogy of the same car, same make and model. So the will-based car, they both are the same type of vehicle. When you pass away, they transfer assets to your loved ones in that car, in that vehicle. Now with the will-based car, when you pass away, that car has to go into the shop. And so in my analogy, that shop is the probate court. So it goes into the shop to get tires rotated, oil changed, all the maintenance, and then it's ready to go on that journey. So an executor or an administrator is appointed to drive the car, and it's ready to go on that journey. With the will-based car, when you pass away, the trust-based car, because you've done oil changes and tire rotations and all the maintenance throughout the life of the vehicle, it's automatically ready to go on that journey. And so it does not have to go into the shop, it's ready to go. So in essence, you can do the same type of planning with both vehicles. It's just making sure you understand that one has to go into the shop before it's ready and the other can go automatically when it's ready. And so we'll talk about how those differences affect how you and your clients will perform. So let's talk about that first basic technique, passing away without any plan in place, or what we call in Georgia intestacy. That means your client or you pass away without a will or without any sort of trust or planning in place. So in this case, you pass away, let's say Fred, because we know statistics also tells us that the man or the husband will pass away before the wife. So in this case, I'm always going to say Fred passes away before Wilma. So Fred passes away and he leaves Wilma. Assuming in this case, Pebbles is not around, has no other siblings. So Fred passes away, leaves just Wilma alone. And so Wilma will inherit all of his probatable asset. Now, in the other scenario, Fred passes away and leaves Wilma, but now let's say Pebbles is alive and Pebbles has some other siblings. According to Georgia, half that property will be shared by Wilma, but not less than 1/3, and that's just only a specific because of the state of Georgia. And then half will be inherited by the children. So in this case, Pebbles and any other siblings that she may have. So you may think in an ideal world, hey, I don't need to worry about any estate planning. I can pass away without any of those documents. And we know that Fred loved Wilma. He loves Pebbles too. So guess what? They will share the property equally and not have any issues. Where some of the issues come about and where you'll see the problems is in a scenario where, remember, the children that we're talking about inheriting here are children of the person who passed away, in this case, Fred. So what happens if Fred passes away and has children from another marriage or has children outside of wedlock? Now you could see a scenario where Wilma is now sharing this property with all these other children that may not be her children as well. And so you can see where, yes, that kumbaya sort of environment that we originally looked at when we thought about this is not so rosy when we look at the more realistic picture of things. And so this is another reason, again, why we need to properly plan. So in a scenario where you have a will or you don't have a will, the probate court comes into play. The probate court, the process there is to appoint a person to have authority over the real estate so that they have the ability to sell. That person, depending on whether you pass away with or without a will, is called either an administrator if you pass away without a will, or an executor if you pass away with a will. But again, they have the same responsibilities. They have to gather assets, they have to pay off creditors, and they have to distribute the assets. And that second point is important because the number two thing that the person has to do is pay off creditors. And so there may be a delay in the probate process having to notify those creditors. And so there may be a delay in being able to sell the property. And court will have to be involved in that process. And making sure, like in our scenario where Fred and Wilma moved from California, they still have that California property. So although it doesn't involve you particularly because you're listing their Georgia property, you still have to be aware that it may delay things because now they have to probate the estate in California in addition. And so those are some of the considerations that you have to think about, especially if Fred passes away without a will. So when we defined estate planning, we talked about control because that's very important. Now, control during lifetime is not an issue. Again, you're fine, you're alive and well, you can handle all your affairs. It's not an issue. Where it really comes into play is in incapacity and debt. So Fred becomes disabled, he's still alive. What happens now? He owns property. How can he transfer that property, or how can he sell that property? Because maybe Wilma can't take care of it by herself. And what happens if Fred passes away? What do we need to do to maintain that control? So as a general rule, when we're talking about estate planning and talking about ownership, is that the owner has an interest in the real property in her name. And if she loses capacity or dies, someone else has to be granted control or authority. And so that's always important. That's why when we send contracts to our office to do closings, and we have to identify if the person's disabled or if the person's passed away, well, who has the authority to handle this real estate transaction on behalf of the person that has passed away? And so those are some of the considerations. So let's talk about incapacity and debt. So without any planning, without any advanced estate planning, if you pass away, or excuse me, you are incapacitated, so you're disabled, your client cannot do anything for themselves, they're incompetent, then what happens is your client may have to face what's called a living probate. That means that in order for somebody to gain authority to sell that person's property, they have to have guardianship over the person, they have to have conservatorship. Now, guardianship and conservatorship can be one and the same person. Really what guardianship is control over the person themselves, so their body, and conservatorship is control over that person's finances or assets. Again, it could be held by the same person in one, or it could be two different individuals. But again, you can see how authority without any sort of advanced planning, so your client or you are incapacitated, how do you then conduct any transaction? You have to have a guardian or you have to have a conservator. At death, that is the same concern. You'll have to have judicial control, meaning that you'll have to go to the probate court and request for somebody to be appointed as the administrator of the estate so that they can handle all of the decisions associated with that. So we know in those situations, again, it could be delay, publicity to a certain extent because it's all part of the public record, and there's some additional expenses. Now, if your client or you have envisioned those expenses by doing proper planning in advance, then it's not too bad in terms of being here in Georgia and having and incurring those expenses. But you have to incorporate everything when you're dealing with clients, especially as it relates to their real estate. So planning with title. We talked about ownership of title, real property in your case. So individual name, in the case of Fred owns the property here in Atlanta outright, a single man, and he owns and controls it 100%. So that's fine. Another way of owning property or title is by jointly. So this is where you have two or more people owning property. In Georgia, there are two ways you can hold property. The first of which is tenants in common. So this is typically, you see that in non-married couples, but in this case, Fred and Barney decide on their partnership, they're going to hold the property, investment property primarily as tenants in common. And so half will own one half of the property, the other half will own the other. I'm going to explain joint tenants, and then I'll come back and explain the differences between the two, or the benefits, I should say, between one or the other. The second way that two or more people or multiple owners can own property is joint tenants with right of survivorship. That means in a case, two people own property, and then there's magic language in that deed, the vesting deed where they gained ownership to the property. They list there as joint tenants with right of survivorship, meaning that if one person passes away, their half of the property automatically goes to the second person. So without having to do anything, without needing a will or passing away without a will, by law, it automatically goes to the person. So now, hearing those two definitions of estate planning or owning property as multiple owners, tenants in common or joint tenants, who would you think by default, if you didn't in that deed where you gained ownership, if your clients didn't put anything, what would you think the default is, tenants in common or joint tenants? And I know that we can't see anybody, but if you want to, in the chat, if you want to just put in what you think, is it tenants in common or joint tenants by default? So if your clients bought property, multiple owners, and they didn't have any language in there talking about how ownership was being held, how do you think that Georgia would look at that? And I'm going to maybe pop up the chat a little bit, see if anybody's answering, paying attention. I see Michael is saying tenants in common. Anybody else? Lisa says tenants in common. See, this is bad. I'm dealing with real estate agents. When I deal with the general public, most of the people would say joint tenants, but you are right, Michael, Lisa, that is correct. By default, if two or more people buy property and they don't put any language in them, then they automatically own the property as tenants in common. So you can see where that could be an issue, where especially if they're married, you now buy a property, you don't have any magic language, and it says, Georgia says by tenants in common. So if Fred passes away, now Wilma will own half of that property outright. But now, in terms of Fred's share, she would own, again, depending on whether Fred passed away with or without a will, she would own half of Fred's half, and then the other half would be shared by Fred's children. So again, you can see how owning property as owning property of two people without any magic language can cause some issues. So we as a real estate firm, to avoid some of that, by default, when you do a closing with us and we know that you're married, we will automatically put joint tenants, because we know, again, majority of people don't plan, they don't have an estate plan, they don't have a will at the minimum. And so what we want to avoid is if the husband passes away, that the person will automatically own, the spouse would automatically own the property at their death. So you can see how, again, joint tenancy is ideal in a scenario where two people own the property and they're married together.
So Thua, there's a question in chat from Sophia. She's asking, does joint tenancy, can it only occur when both owners are on the deed at the same time?
Sophie, that's a great question. And the answer is no, it's not necessarily at the same time. Remember, it's magic language. So on that deed where the two people gain ownership, if after their names, it doesn't say as joint tenants with right of survivorship, then Georgia defaults to tenants in common. So the only way that we know is by that language on there. So it's not on the timing, it's about the language at the end there when they gain ownership to the property. All right. So we're going to continue on. So the other way of holding property is a living trust. And as I mentioned, the two vehicles, the difference, because you've done the maintenance and the rotation throughout the life, it's automatically ready. So a trust, the other difference is the will doesn't become effective until you pass away. Whereas a trust, because it's a contract by law, it becomes effective upon signing. And so whereas a will can't really hold property A trust can. So you can retitle the assets in the name of the trust because the trust automatically becomes effective upon signing. And so another way that couples or individuals can hold property is through a trust. So you can have a single trust. In this case, Pebble's single trust is Pebble Flint So's Living Trust, or you can have a joint trust where primarily we have joint trusts for married couples. I have to go through several factors to determine whether a married couple can have a joint trust together or two separate married individual trusts, depending on how long they've been married, how common or combined their assets are together. Do they own accounts together? Do they own properties together? Do they own businesses together? That's what determines whether they have a joint trust as opposed to individual trusts. One of the key things there is making sure that, again, the way that things get into this trust so that it owns it is that everything has to be titled in the name of the trust, or more specifically or technically, it has to be titled in the name of the trustee. So you'll see sometimes when you're listing a property and you ask who the owner is and they say my trust, and you ask for maybe documentation, the property is actually listed as Fred and Wilma Flintstone as trustees of the Fred and Wilma Flintstone Living Trust. And so that's how the property is placed into the trust. So when they transfer it, they'll be selling it as trustees of their trust. Okay, and I do see the question there from Michael. If this property were owned in a trust, what are the benefits, if any? Now, from a living trust standpoint, there are no, you have to look at a living trust as a vehicle for transfer, for ease of transfer. So there are no real benefits other than making sure that it transfers easily from you to your loved ones, and it affects your ability, or if you were to become disabled, that within the trust documents, because it's there when you sign, you can put what we call disability provisions. So you can put provisions within the trust that says, hey, if I happen to still be alive, but I'm disabled, what do I need? What happens in order for me to be able to either sell this property or maintain this property or manage this property or maybe transfer this property? And so within that trust, you're able to put provisions in there about disability, and it makes it easier to transfer it. So when you pass away, because it's in the name of the trust, when you pass away, you already have provisions in there as to who is to take over from you after you pass away. So who is that successor trustee? Is it Wilma? Is it Pebbles? And so when you pass away, we don't have to do a probate because it's in the name of the trust. It's not in your individual name. And so that trustee can now step into your shoes and sell the property or move assets to whomever you want them to be moved. So that really is the prime benefit of having a property within a trust, within a revocable living trust, because you'll have to understand there are various types of trusts. Our preliminary conversation today about estate planning is about the most standard of those trusts, which is a revocable living trust. So thank you for that question. So again, and that leads into perfect. And I'll come to your question, Lisa, and then let me talk about the benefits since it ties into the question that Michael asked. So again, the benefits are avoiding court involvement, because even during incapacity or disability or death, you have within that trust document provisions there talking about how things are to handle. And it does avoid probate, so it does avoid some additional costs that you may not envision. And it's easier, it's a faster transfer from there because it's in the name of the trust and there's no real process to go through probate. You can transfer it. It does provide some level of asset protection and reduces estate tax liability, depending on, again, the size of your estate. Most people, that's not a concern. In this case, we're not dealing with estate tax implications, but that is, again, a further conversation. So let me address the question that Lisa brought up about if you had an LLC that owns property with an operating. So her question is, if you had an LLC that owns the property with an operating agreement, wouldn't that accomplish the same? And yes, that is correct, Lisa. Now, we talk about real property being owned by a trust primarily when we're talking about your primary residence. Because in a primary residence, there's no business need for you to place that in an LLC. And so what you do is you place that primary residence directly into a trust, or you have a will that identifies what happens to that primary residence. Where LLCs come into play is when you're dealing with non-primary residents. So let's say Fred and Barney decided to buy a property together. I would advise those individuals to set up an LLC to make sure that the ownership of that is done within the LLC. And within the LLC, within the operating agreement, you can have provisions of what happens if Fred passes away or if Barney passes away. What I would further recommend, especially in Fred's case, because Fred is my client in this case, I would recommend that Fred's half of that LLC is owned by his trust. And so therefore we add a further provision in there that helps transfer. So what if Fred didn't want to give Barney his half of that LLC or that property? Maybe he will transfer it to his trust and allow his beneficiaries to be either to have Barney pay them off or to be able to come into business with Barney. Again, yes, it's a complicated structure, but you do have an LLC and where we have the trust own the shares of that LLC. I'm going to address the next question before I move on. The question is from Hillary, and it says, can a trust have rules of distribution after death or disability, meaning the beneficiaries of the trust can only receive X number of dollars on a monthly or annual basis? Absolutely, yes. And within a trust and even within a will, you can put restrictions on distribution. You can say, yes, they can only receive X amount if they do X, or they can only receive X amount over a period. I always try and counsel clients not to add as too many restrictions. What I always counsel clients, instead of putting in too many restrictions, make sure that the successor trustee, that the person who's going to take over from you, is well versed in being able to look at the scenario. So for instance, if you have all this restrictive language, Fred has this restrictive language in his trust, and he passes away, and Pebbles happens to be disabled. And Fred has said, well, I want Pebbles to go to college. I want her to get A's. I want her to get a 3 point whatever GPA. What happens if Pebbles gets disabled maybe the day before her college entrance? Now, all of a sudden, you've provided these restrictions within the trust that don't apply to the day-to-day, the current activity. What I would say instead is make sure that your trustee understands where your preference is, provide them with a box and say, hey, this is what I would prefer. I would love for Pebbles to go to college, but if she happens to be disabled, hey, I want you to take care of Pebbles because I love her and I want you to make sure that she's taken care of. So yes, you can put within a will or even within the trust restrictions on the disability. But what I would always say is make sure you have a well-versed trustee or a competent trustee to be able to handle those things because they will be on the ground executing your wishes. So hopefully that answers the question there. So let's go and let's talk about more in terms of issue spotting. And that'll bring out, I think, some additional questions, but it'll also talk about some of these techniques that we talked about. So in this case, you have a client that wants to transfer property between family members. So in this case, a parent wants to add a child as joint tenant. I always sort of counsel my clients that in a scenario where maybe you have one child, like in Fred's case, maybe Wilma has already passed away. So Fred wants to add Pebbles on. If Pebbles were Fred's only child, I would say, okay, that's fine. You can add Pebbles on. But understand that Pebbles now becomes an owner of the property as joint tenant. So Fred, if you 5 years later have an issue or a concern, or you and Pebbles have a falling out, you can't thereby take Pebbles off of title. You have to then institute a lawsuit in order to remove Pebbles off. And also the risk of loss of the property. When you add Pebbles on, you're adding any of Pebbles' creditors that she may have. So maybe Fred wants to do a credit check on his child Pebbles before adding her on to make sure she doesn't have too many creditors, because all of a sudden Pebbles' creditors and or debts could be potentially attached to the property. So if Fred in the future wanted to sell it, Pebbles not only now an owner has to sign off on that, but Pebbles' creditors could also now be a part of that. And so it really is a case-by-case basis on adding a child. If you have multiple children, I would say either add all or don't add any. Again, make sure you have a will or make sure you have a trust that properly identifies what happens to that property. because what it could be a situation where Fred, before he passes away, needs to go into a nursing home or other care, or needs to use that property or sell that property. If you add a child now, you're now having to get that child's agreement before you're able to sell the property. So it could cause some unintended recipients to have the property. So that's one of the issues I see in joint tenants. The same thing again when you're adding a child during the lifetime. The same sort of scenario could occur there by adding or transferring property within family members during your lifetime. Again, what I always counsel clients is that's an irrevocable transfer. So when you make that transfer, if you change your mind in the future, unless that you and that child or that family member has a good relationship, they don't automatically will automatically say that I can get that property back. And so it's important to make sure that if you're doing those type of transfers, the best way to do it is within a will or within a trust. And this, I think we see most of the time when we have clients that lose capacity during a transaction. So you've listed the property, Fred and Wilma's property here in Atlanta. They want to sell. You've listed the property. And then during the process prior to you listing, maybe even after you get a signed contract, or maybe before then, in this case, you probably get multiple offers even before you list it. So let's assume you have an offer, and then shortly thereafter, Fred becomes incompetent. So now if Fred and Wilma had owned that property as a trust where you can put disability provisions in there, it would be easy for Wilma to assume ownership of that transaction and be able to see it through the end. Now, if Fred had a will, which is okay, which is the next best thing, in addition to a will, because remember what I told you, the will doesn't become effective until you pass away. So in this scenario, Fred is still alive, but he's just not able to handle. In addition to that will, we would need a document to handle Fred's affairs while he's still alive. So in this case, it would be a durable power of attorney. And the reason why we say durable, because durable means that power of attorney will still be in force even during Fred's incapacity. So it's in place, and it does speak to who is Fred's power of attorney or his agent to handle his affairs there. The worst case scenario, again, Fred has no trust, Fred has no will with a power of attorney. And so what has to happen now? Fred has to petition, Wilma or a family member has to petition the probate court on Fred's behalf, and the court has to appoint that person as Fred's guardian and or conservator to be able to handle the real estate transaction. So you can see how that would be difficult. So even if Fred is married to Wilma, because Fred owns that property half, Wilma doesn't automatically have the ability or assume the responsibility to continue on that transaction. Wilma has to be given authority by the court in order to do that transaction. So I see Lisa's question. It says, how do you counsel clients on determining the criteria for identifying a trustee, guardians, etc.? So that's great question, Lisa. What I always counsel, the first thing I do with clients, I always like to tell clients that we work in the estate planning world, we work in rules of three. So in order to identify trustees, guardians, or what we call fiduciaries, which are any individuals that will handle your affairs, I want you to identify three people. So if the first person is not alive or doesn't want to do it because of the responsibility, then you have a backup to that person, and then you have a backup to that person. Now, part two of that question, the question or the answer, part two of the answer is that you have to identify competent people. Now, I would say competent family first, then competent friends first, and then if you don't have competent family and friends, then you have to find other professionals that you can identify to act as your fiduciary. But you always want to know that you want people who can handle this affair, whether it's you during disability or you at your death. They have responsibilities, basically almost managing your affairs for you. So you want to pick the people sort of correctly to be able to handle those affairs, whether they're children, whether they're other family members. Identify people who you believe are competent. And so that's, I think, the key criteria: competency, and making sure that you have at least three people, so that in that situation, you'll always have somebody in place to act on your behalf or your client's behalf. All right. So thank you for the question. The fourth issue spotting is, let's say Fred passes away during that transaction, so you're listing the property. So Fred now passes away again. If Fred had a trust within, because man, the trust, remember the trust becomes effective upon signing. You have disability provisions, you have death provisions. It's in the name of the trustee. Within that, there's always language in there as who's to become successor trustee. In most cases, if Wilma and Fred own that trust together as a joint trust, in most scenarios, and what I do with the majority of my clients is Wilma then becomes the sole trustee within that language. And so all we'd have to do then is maybe do an affidavit that now says, hey, Fred has passed away, here's his death certificate, and based on the terms of the trust, Wilma is now the sole trustee. And we're good. No need to involve a probate court. So that's the best scenario. The worst or the next, again, is the involving the probate court. Now, having a will, again, in Georgia is not bad, not a bad thing, but making sure that it's properly planned. So in that case, we would submit the depending on, again, and I'm complicating things just a little bit, but remember, we're talking about issue spotting at death. So your first concern, your first issue now is how did Fred and Wilma own the property? Did they own it as joint tenants, meaning now that Wilma owns the property outright by law? Or did they own it as joint tenants, which means Fred's half goes to his estate and Wilma keeps her half? So if Fred passes away without a will, and the language is tenants in common, we have to probate, and that person is the administrator. Tenants in common, Fred passes away, we still have to probate, but that person is now the executor. But if Fred and Wilma were as joint tenants, now no probate. That now becomes Wilma's property. All we have to do, and this is a technical thing, you don't have to worry. All you have to worry about is, don't worry, you just need now Fred's death certificate. Submit that to the closing attorney, and we do an affidavit at closing to be able to handle that transaction. But we don't have to worry necessarily about probate because we know Fred and Wilma were on as joint tenants. But if they weren't, that's when issues can occur. Or if Fred only owned the property outright by himself, we know that without a trust in a will alone, we would have to do probate, depending on whether he had a will or didn't have a will. Now, residents owned inside an LLC. Now, this is an issue spotting because number 5, the first thing I want everybody to know is this is probably a no-no. You do not want to hold your primary residence, or you do not want your clients to own their primary residence in an LLC. First of all, is it loses corporate protection. So the whole reason people form companies or LLCs is to provide what we call a corporate shield, so that if anybody sues them, that the person suing them is only limited to the assets in that corporation. They can't go after the individual's assets for the most part, unless other things happen. So for the most part, they're limited in liability to just that company. But when you start adding your primary residence in there, that's a sign to the court that you're not using that LLC as a company, that you're using it as your personal asset. And so if somebody now sues, the court's going to look and say, well, hey, you kept your primary residence in there. So that tells me you're not really using it as a business. So now, hey, I can give that person who sues access to all your personal assets. So in general, you do not want either you directly or your clients owning property, their primary residence in their LLC. You want to keep investment properties and other assets in that LLC. And then there's the risk of increased taxation, especially here in Georgia. You cannot file for homestead exemption on your primary residence if you have it in an LLC. If you have it in a revocable living trust, you can. If you have it in an LLC, you cannot. And so that's one of the issues, again, that in terms of taxation, why you would not have that property in an LLC. So again, best advice for your client is either keep it in your individual name or put it into your trust for ease of transfer upon disability and death. But definitely remove it out of your LLC. The other issue spotting, a client's own property in other states. So this is key. When I look at clients come to me and I don't automatically put people into trust as opposed to a will, because frankly speaking, a trust costs almost 2 to 3 times more, or I should say a trust-based plan because it's more than just a trust, costs more than a will-based plan. So you would think if everybody comes to me, I'm putting everybody in a trust. That's not always the case. I always have these factors that I look at to determine whether a trust is more appropriate for a client or a will is more important. And one of the factors is owning property in other states, because every state that you have a property in, you have to conduct a probate. So if Fred passed away in Georgia, still owning his California property, we would have to do a probate in Georgia, depending on how he and Wilma own property. Remember, joint tenants, tenants in common. So depending on how they own the property, we would have to do a probate in Georgia, but we would also have to do a probate in Bedrock, California, or the county that Bedrock is in California. So we'd have to do 2 probates. Now, Fred to me would have been an ideal client for a trust, because what I would have is I would have placed Fred's primary residence here in Georgia in a trust, and or I would have placed his California property in an LLC, then a trust, or directly into the trust. Either way, when Fred passed away, a resident of Georgia, because the assets were now in the trust, we would not have to do a probate in Georgia, and we would not have to do a probate in California. So for clients that come to me, or clients that you have that have properties in different states, that's an automatic red flag. You need to be in. You need to have a revocable living trust or a trust own the property to avoid probate in those 2 states. So the other issue spotting, client wants to transfer property to child, inheritance or lifetime gift. Those are fine. Again, you can do that within a will or within a trust, because even within the will, you can have what's called you could have trust provisions into the will. It's really what's called a testamentary trust. Again, only difference is it has to go to the probate court to be probated before the trustee can be appointed. Whereas if you put those same provisions in the trust, they automatically will have that ability once you pass away. But it's in this scenario, again, it's easier to make those transfers within your estate planning documents, as opposed to doing the transfer outright or adding a child onto title to that property. And you can place it. I think Hillary's question from earlier, not only about restricting distribution, but controlling distribution to a certain degree. So if you had a residence or you had a property that you wanted to keep in the family, you can restrict the ability to transfer shares in that, because now you'd have a sort of an LLC, but you'd own it in that sort of family trust, and you'd be able to restrict the ability of the family to sell that property for a period of time, so that they can either keep it within the family and own, have sort of a legacy and rent it out or something of that nature, but it can only be kept within that family. And so you can do that sort of transfer within either, again, a will or ideally in a trust. So it stays within the family. And you can also help. So if you, like in Fred's case, Fred loves Pebbles, but he's not too fond of Bam Bam. And so you can, within that document, sort of restrict the ability of Pebbles Pebbles in this case to transfer to Bam Bam. So Fred could say, hey, Pebbles, in order to keep it to family, you can only transfer it to your children, not to your spouse. In this case, that's why I always have a conversation with clients. I always ask them, tell me about your relationship with your daughter. And then that always leads into, tell me about your relationship with your daughter-in-law, your son-in-law or daughter-in-law. And it's always that sort of a mild question really leads into scenarios like this, but they don't really know that until we start having more conversations. Because if I get a sense that relationship is not great with the son-in-law, then my recommendations may be a little different. At the end of the day, it's the client's objectives that are being accomplished, and I'm only providing recommendations. So those issues spotting, the most is just being proactive, either you individually as an agent or you as an agent representing clients, making sure that your clients or you have a properly drafted estate plan that has disability provisions. So within the trust, you can have those provisions. If you have a will or your client has a will, you'll need a durable power of attorney or another document that will have those disability provisions. Again, because we know that a will doesn't become effective until you pass away. So if you don't remember anything throughout this presentation, I want you to remember that fact, that it doesn't become effective. And making sure that it's properly titled in a trust if it's a primary, you or your client's primary residence, or in an LLC if it's their investment property. And making sure that, because it's the most effective way, again, having a plan, an estate plan is the most effective way of transferring property or assets, whether they're passed away or they're disabled. So I'm going to give you sort of a hint of what a comprehensive plan, because I've hinted at it a few times. So again, it's a trust-based plan or a will-based plan. So a comprehensive plan is a trust fully funded. And that's, I think, the important part of understanding what a trust is and why a trust is important. It's funded, meaning that you're directing assets to a trust. And that's why I tell clients all the time, after you sign your trust, the work is not done. We still have to do heavy lifting where we have to now redirect assets. So if you own property, your primary residence, we direct it into a trust. If you own investment properties, you place it into an LLC, and then you place those into a trust. If you own a bank account or any other assets, you're just making sure that the trust is either listed as the beneficiary or the trust is an owner. So you actually have to fund that trust. So the plan could be either be a trust or a will, a complex will, not a simple will. It has instructions in there, again, what to happen upon disability and death. Now, if you have a trust-based plan, in addition to that, your plan would have what's called a pour-over will. That is simply a will that, hey, if we forgot to place everything into the trust, or you acquired something after the fact, we have this sort of skeleton will that only is in there to tell this person, hey, executor, take this asset that I forgot to put into my trust or I acquired afterwards and pour it over or place it into the trust. Now, it also includes some guardianship provisions. So if Pebbles in this case were a minor child, you have to put guardianship provisions within a will and not necessarily a trust. And so you would have those provisions in there for taking care of minor children. So any child under the age of 18 is considered a minor. So that's where the differences between the trust and the will differ. So a trust-based plan would have a pour-over will. Obviously, a will would just be by itself. But then you would have additional documents. That's why I always tell clients, I talk about estate planning. I'm an estate planning attorney. I'm not a wills attorney. I'm not a trust attorney, because I want people to understand estate planning is complex. It's not just doing a will, or it's not just doing a trust. It's making sure that all the additional documents are together. So we know the next item there, that durable power of attorney, can be done with a trust-based plan, even though you include those provisions within the trust, because a trust is, in some situations, a private document. So let's say you're doing a real estate transaction that's owned by a trust, or you're doing something that's not outside of real estate, that is outside of real estate. You don't always want to give people a copy of the trust. Maybe you want to give them the power of attorney that says the same type of thing that person now takes over when you disable. So it's easier maybe to share the durable power of attorney as opposed to the trust itself. But also in the will-based plan, you definitely want the durable power of attorney, because remember, the will only becomes effective upon your death. Before I go over the other documents, what we call the ancillary documents, I'm going to answer Hillary's question. So it says pour-over will is only upon the death, but avoids probate. No, it doesn't. So a pour-over will still has to go through probate, because we forgot to put it into the trust, or we acquired, either we forgot when we created the trust, or we acquired the asset afterwards. So the pour-over will is sort of the catch-all. We still have to go through probate, but it should be fairly simple, because the job at that point is simply, hey, take that asset that I forgot to put into my trust and pour it over into my trust. So we still have to have it just in case we forgot. Now, in an ideal scenario, everything is already in a trust. We don't have to worry about it. It's there. Now, Sophie raised her hand, but I don't see her question, and I know you're in mute. So Sophie, if you can type your question into the chat, that may be the best way to get it, and I'll address your question at that point if you can. If it's more complex, then we can take the conversation offline. I'll provide my contact information there, but it may be easy. But while you're typing your question, I'll go through the other sort of what we call ancillary documents, the other documents that come either with the will or the trust. The other thing is the advance directive for healthcare. So what an advance directive is is the document. It's what used to be called the living will or the healthcare power of attorney. A few years ago, Georgia combined those two. Oh, thank you, Sophie. I answered your question. Perfect. So I'm going to check you off here and make sure. Okay, great. So the advance directive is a combination of the healthcare power of attorney and a living will. So the healthcare advance directive, the way that you look at it, the durable power of attorney handles all your affairs outside of medical. So it'll handle paying your taxes, paying bills, handling your social media, anything. So if you look at our documents, they're fairly comprehensive because we don't want to allow a person to have to get disabled and not have an ability to do anything. Now, so the advance directive is specifically for medical. So it's identifying who to make decisions on your behalf when you're hospitalized and cannot communicate. So those people are called healthcare agents. It's also to tell them what is to happen. If I'm in a coma or if I have a terminal illness, what do I want to have happen? Do I want to be kept alive as long as possible? Do I want to be allowed to pass away? Hey, am I fine with having an autopsy? Am I fine with donating organs? Do I want to be cremated, burial? All those things are medical decisions that are put within that advance directive. And in line with that advance directive, you have a Hipaa authorization form. Hipaa is the federal law that protects the privacy of your medical information. And so if you've identified individuals that would make those medical decisions on your behalf, the healthcare agents, you also want to give those individuals access to your medical records to make those decisions on your behalf. And so in addition to that, you want an anatomical gift form. So if you want to give your organs, not only can you put it on your driver's license that you're an organ donor, but you can also create another form. The other item there, memorial instructions, is probably something that most people probably take for granted. And I have all my clients do it. Memorial instructions are just simply how you want your funeral to be conducted. It's very sort of, it's not mandatory. Your family doesn't have to follow those, but it's always a guidance to your family because what I always tell people, so my father passed away about in 2017, almost 5 years ago. And he had lived in Africa a long time. He was only in America for a few times. He'd been married to my mother for years, almost 50 years. We didn't know where he wanted to be buried. And so a simple memorial instructions would have, if he had written it down, would have told us, hey, do you want to be buried here in the States, your new home, or do you want to be buried back in Sierra Leone, your old home? So those are things that even the minute details, it's easy for your clients, your loved ones to be relieved of that burden. Allow them to grieve for you without having to worry about every single detail associated with your funeral. So that's why I have my clients do that. And then lastly, in addition to all those, we have a personal property memorandum, which is simply just a fancy word for a list, because you have so many personal items that we can't put all of those into your trust or that we can't put all of those into your will. And so we give you a simple memorandum or a list where you can identify the personal asset and who it's to go to. And then within the will, we just say, hey, look for that memorandum to say who that personal property should go to. And if, by the way, I don't have that memorandum, by default, I want my personal property to go to, in Fred's case, Wilma, or maybe to Pebbles. And so that's what really a comprehensive plan is. So what can you do as a real estate agent, or even individually or in your professional capacity? Just be proactive. Don't wait until the transaction fails in order to properly identify these scenarios, these issues that may affect it there. Educate your clients, educate yourself on knowing and understanding what the benefits are about estate planning, and making sure that you've identified an estate planning attorney to handle those. In my firm, I handle the estate planning, I handle the wills and trusts, but I co-manage our practice, which the other side of that is the probate, and I have a partner that handles that. So if for some reason you have a client that has passed away, they also have the ability within our firm to be able to handle your probate. Our running joke, in order to, even within my firm, my attorneys just understand that my partner, Burke, he sees dead people, and so he handles the probate, whereas I don't. And so that's a way for us to delineate between who does what, and so that's easy for that. Wanted to ask the question about whether the recording is, I believe, and Michael and Lisa can confirm, but I believe this presentation is being recorded, and so you'll have access to it afterwards. If not, just send me an email and I can shoot you the actual slides because it's in a PowerPoint presentation. So that's fine. We can do that. Hillary's question, and I know we're almost at time, so I want to be mindful of your time. But Hillary asked also, what happens if one spouse has a very old will that have deceased beneficiaries? So the short answer and my lawyer answer is always it depends. I'd have to review will, but assuming those, what I would do in my case is we always make arrangements of what happens to those beneficiaries if those beneficiaries are deceased. And so we always have provisions within the will that says if A is deceased, I want it. So in this case, Fred, if I counsel Fred and Wilma's already passed away, I would say, hey, if Wilma or Pebbles pass away, what do you want to have happen? Do you want it to go to Pebbles' children, or if Pebbles has a sibling, do you want the share to go to Pebbles' siblings? So those are I would say hopefully that will identifies again those deceased beneficiaries. If it doesn't, it's almost like that person passed away without a will, and we would go based on what Georgia law says the beneficiaries of that estate should be. And so those are, to answer your question in short, Hillary, it depends, but it goes by, we would put provisions in there. What happens if one person passes away? It should go to a next person, that person. And then there's a default. So within the will, there's a default provision it's called contingent beneficiary distribution. So if it doesn't, if all the people that I've listed here have passed away, then go to what Georgia law says, and then it goes based off of what we call descents. I forgot levels of descent, and it's basically whoever inherits under Georgia law will inherit under there. So I know we've asked questions throughout, and I see Hillary has one. What if the spouse is not listed in the will? If the spouse, well, besides that being a big family law issue, if the spouse is not listed in the will, so a couple of things. So Georgia is a very spouse-friendly state. Let me say that. And so Georgia has a provision that we didn't really talk about called year support. So that means that a spouse can file a petition for year support and say, I want X amount of the estate for my year support. And this would even trump a will to a certain degree. I mean, we're talking now having to combat what the provisions are in the will and what the spouse would want. But, and so I typically see those scenarios of year support where there's no will, but you could potentially do it where there's even a will. But again, this is a scenario where there may be a contesting of the will, because what I would tell clients all the time, if I were counseling Fred and Fred didn't want to leave everything to Wilma, I would tell Fred, A, you need to make sure in the will you say you don't want to leave something to Wilma. And then B, I would say, Fred, leave something small to Wilma, and specifically say in your will, if you contest the will, not only do you lose everything else, but you lose that something small. And so Wilma may not want to then contest the will and just be satisfied with that small. So I know that's a long-winded answer to your short question, but you can see again why the scenarios can be a little bit difficult. Again, best to plan, best to have the provisions. If not, then you're having to deal with interpretation and deal with the court's decision on that. So we're right at 7 o'clock, so I must have timed this presentation well. We do have some time. This is my contact information. I put all the offices there, but the estate planning office is primarily in Conyers. One of the good things about my firm and why I enjoy working with Lueder, Larkin, and Hunter is we have 26 plus offices in Metro Atlanta. So from an estate planning standpoint, I have clients in Cumming, Alpharetta, you name it, that aren't near to Conyers. So with technology and Zoom and Google Meet, we're able to converse with the clients, and then they can either come to Conyers on that one time to sign documents, or they can go into any one of our offices and sign documents. And so that's, from an estate planning standpoint, it's a great marriage here with the firm. But even on the real estate side, we have clients, real estate agents that are primarily out in Conyers, but let's say you have a property out in Douglasville. We can handle everything here in Conyers, and we can close or schedule it to be closed in Douglasville. So that's one of the benefits that I see with Lueder, Larkin, and Hunter with our relationship with real estate agents and realtors like yourself. I'm going to answer this last question, and then you have my contact information. Definitely feel free to give me a call. You may have to remind me where Get you, because my memory is not as great as it used to be, which is great for my estate planning clients, because some of them sometimes are hesitant to tell me everything, and I have to remind them, this is why I keep notes, because 15, 20 minutes after our conversation, I'm going to forget everything because I have so many other clients. I'll still remember it when it's time to making sure your documents are customized, but don't have to worry about me sharing any information. What's the average cost for estate planning with your firm? So I'll tell you. So our will-based plans start at $750, and our trust-based plans start at $2,500 for an individual trust, or $3,500 for a joint trust. So those, and I always like to stress start, because our estate plans are customized to the client. And so depending on the provisions that need to be added, depending on your loved ones, that could change. I always like to say this in the best way. I have two clients. They're both millionaires. They have the same amount of dollars, but this one client has 5 children, 4 of which are under the age of 18, and the 5th one happens to be in jail. The other client has 5 children, all adult, 5 children, no issues whatsoever. You can see whether we do a will or a trust for them, this person's will or trust will be a little bit more, or be depending on that kid that is in jail. It may be a lot more than the child than the client whose children are all adult, dealing well. So really is about solving issues and how we differentiate the charges between clients. But for the most part, they fall within those general ranges. It's a great question to end the presentation.
Thank you so much.
Contact me if I can help you in any way, and I appreciate the opportunity to talk to you today.
Thank you so much, Thua, for taking the opportunity to share with us. We really do appreciate your time this evening. And for those of you who've had a chance to join, please take a moment. If you like the content and what we shared, please like us on Facebook, do a Google review. You can like Lueder, Larkin, and Hunter, as well as EXIT Realty West Midtown. We will be presenting other topics in the future, and we thank you all for joining us.
Thank you, Lisa. Thank you.
All right, have a good one.
You too.
Thank you all. Great job, Thua.
Thank you.